And as well, we've just begun recording for our webinar. Thank you. Welcome. We've got friends from Leamington, from Barrie, London, Ontario, Aurora, from Ottawa, Elliott Lake. Welcome everybody from all over the province and the country. Thank you. And just again, we'll start in just one more moment as I see more and more people are getting logged in. And good morning, Carla from Westminster, BC. Thank you for joining us. We will begin because I know we have a very, very jam-packed webinar ahead of us today. So thank you and good afternoon, everybody, for joining us. My name is Mary Shakuri from Elder Abuse Prevention Ontario, and I'm joined with my colleague today, Sheila Schuline. And we're taking you through today part 2 of our Power of Attorney Q&A and panel discussion, getting your questions answered. For those of you who may have joined us on January the 19th, we had the first session of our webinar where over 650 attendees registered, and we were asked so many very important questions, and we want to thank our speakers for coming back to be able to go over some of those questions that were presented to us. So this session is here to really provide a detailed response to both the live and written questions we had on issues and concerns and questions, and a lot of clarity that people needed related to the legal issues pertaining to the powers of attorney, the mental capacity, capacity tests, and when the POAs are effective. So we are excited today to bring our speakers to take you through that very important information. And as we'd like to begin, we acknowledge that we gather on the traditional territory of a number of First Nations and acknowledge their stewardship of this land throughout the ages. We seek a new relationship with the original peoples of this land, one that is deep, one that is based in honor and deep respect. Thank you. And a little bit for our webinar housekeeping, as always, all our attendees are muted during the webinar, and as well as their cameras are off. And for our speakers, you'll be able to view them when they are presenting and during the Q&A session. We have our wonderful ASL interpreters who will be visible during the entire webinar. And of course, you can view all speakers by clicking on the gallery view, and you can even pin the speakers to have that image on your screen all the time. And we've also pinned them as well. And if you need to adjust the speaker image on your screen, you can simply do that by dragging the line between the image frame and the slides to the left to make the speaker an image larger, and you can view these options at the top of your screen. As well, please feel free to use the chat box to post any comments during our session, and if you can, keep your questions into the Q&A box, and myself and Sheila will be monitoring both these boxes. This way we can ensure all questions, if we have not already answered them, we can make sure we have time, and we will post responses as well during the webinar and after as well, so using the Q&A box. Always note that an evaluation will be sent to you at the end of the webinar, because your feedback is so important to us, because this really helps us gain knowledge and suggestions about future topics and what is important to our viewers. So please take just a few moments to fill that out at the end of the webinar. We really do appreciate it. And as always, our webinars are recorded, so you'll be able to view it anytime at your leisure through the Elder Abuse Prevention website, and we'll have that up early next week for you. And we, of course, understand that we want to respect everybody's privacy and confidentiality. We are aware that very personal circumstances may arise and participants may wish to address this. Now, in keeping with our commitment to maintaining your privacy and confidentiality today, we will only be answering general questions posted through the Q&A. Please, if you wish to discuss any specific circumstances, we invite you to contact Elder Abuse Prevention Ontario after the webinar to arrange a confidential conversation so we may further assist you. And for those of you who may be joining us the first time, again, welcome. Elder Abuse Prevention Ontario's mission is to envision our Ontario where all our seniors are free from abuse. They feel safe and have a strong voice and are respected every day in our province. We work by bringing public education and awareness to promote awareness about elder abuse and continue to provide information on how and where to access services. We train a variety of staff from a different array of sectors, working directly with seniors. Not only is our goal to enhance their knowledge and their skills to respond, to recognize elder abuse, but to how to respond as well. And working with a coordination of our community service providers, because we know by strengthening communities across our province and building partnerships, promoting information and sharing their efforts to support, together we will combat elder abuse in Ontario. We always say, simply put, we all have a role to play. And Elder Abuse Prevention Ontario is mandated to support the implementation of Ontario's strategy to combat elder abuse. And as always, we'd like to thank the Ministry for Seniors and Accessibility for continuing to fund this very important work as we go forward. And as we begin, I'd like to introduce our speakers once again for our webinar today. Megan Stuckey is a staff lawyer at the Sudbury Community Legal Clinic. She was called to the bar in 2017 and spent 4 years practicing criminal defense, appearing in the Ontario Court of Justice, Superior Court of Justice, and the Court of Appeal. In 2022, she transitioned into elder and senior law and currently runs the Advocacy North for Elders and Senior program, providing legal services for low-income seniors across Northern Ontario. And with us also is Shauna MacEachern, who is an occupational therapist with over 25 years of experience working with seniors and the disabled. She is based in the city of Kawartha Lakes, but has been providing virtual and in-person assessments throughout Central Ontario and beyond. She works with adults and seniors with memory or cognitive impairments to determine if they can understand, appreciate their financial, health, social, and legal affairs in order for them to make an informed decision and to reasons and problem solve how to manage their affairs. She is also a member of the Kawartha Lakes Haliburton Elder Abuse Prevention Network, and she has a wide networks of connection in healthcare, legal, and social services for clients who have cognitive impairments and who are vulnerable. So welcome both to Megan and Shauna, and thank you so much today for taking us through the Q&A and questions answered for today's session. I will stop sharing my screen and hand it over now to Megan and Shauna. Thank you.
So good afternoon, everybody, and welcome to our presentation. For those who joined me back in January, you'll know that we discussed power of attorney for personal care. So we're going to follow up with that today, just discussing the personal care side. We might talk about power of attorney for property a little bit here and there, but really our focus is on the personal care. we took all of the questions that you gave me at the last presentation and put them together in this PowerPoint for you. So we're going to try to go through it in an orderly fashion, but it may seem like it's jumping around a little bit. So we're going to start with elder abuse, picking your attorney, signing in witnesses, safe storage, and sharing. We'll take a break for some questions, and then we're going to focus on the capacity tests and the role of the capacity assessor. So we'll get started and see how many we can get through. So starting, of course, with elder abuse. So the first question we received was, can an attorney for personal care restrict visitors or outings with friends or family? So the power of their attorney for personal care only has authority to make decisions regarding health, safety, shelter, nutrition, clothing, and hygiene. Absent from that list is access, visitation, and so your attorney really does not have authority to direct who can visit you and who cannot visit you unless it hits that safety issue. And there it needs to be a significant and imminent risk to the health or safety of the grantor. And there needs to be some evidence, right? It can't just be, we're afraid this person's going to do something to them if there's no evidence to base it in. For those who are living in a long-term care home, there's actually the legislation protects the residents' rights. So it's called the Residents' Bill of Rights, and it codifies the rights of residents in the home to ensure that it becomes more like a home and less like a hospital setting or a care setting. And so a few of those rights that we have listed here is, every resident has the right to exercise the rights of a citizen. So just because someone's living in a long-term care home doesn't mean they've lost their civil rights. They can still vote. And notably, right here at the bottom, they still have the right to meet with anyone they wish or to join any organization or group, right? So they really cannot be restricted from doing that. They also have a right to participate in decision making and for that to be respected. So if somebody is saying that they are an attorney for a resident in a long-term care home, and therefore, maybe their sibling John isn't allowed to visit them, that's a decision that's being made. One, the attorney doesn't have that authority, but two, the resident should also be involved in that discussion and that process. Decisions should not be made without the resident being aware of it and part of that. And then, right on the nose, every resident has the right to communicate in confidence, receive visitors of his or her choice, and consult in private with any person without interference. So residents have a right to have visitors come see them. They can meet with friends privately, they can meet with family privately. And so the attorney should not be restricting that right and should actually be fostering it, ensuring that the grantor or the resident is seeing people that they want to see. So the second question we got was, can a power of attorney for personal care be changed or revoked if the attorney, so that's the person that you've selected, is misusing their authority? And the simple answer is yes, as long as the grantor still has the legal capacity to do that. So the test for making the document is exactly the same as revoking the document. Does the person have the ability to understand whether the proposed attorney, so the new person they want to pick, has a genuine concern for their well-being? And do they appreciate that the person may need to make decisions on their behalf? So it's not a high standard to meet, but there still is a standard that has to be met. And so if they can do that, they can revoke the document. Just be aware that any signed revocation or new power of attorney does need to be sent to the attorney who is currently acting and should be sent to anybody who's been relying on that document. So if it was a doctor or the long-term care home, they should receive notice as well. So what else can be done if an attorney is abusing their authority? Well, there's a couple of different boards in here. One is long-term care action. So you can report to them if there's any abuse in a long-term care home. There's also the Retirement Home Regulatory Authority, and I believe they have a duty to investigate allegations of abuse, and there are duties on staff members to report abuse if they see it. You can also report to the Public Guardian and Trustees Office. They have an investigations unit. And then, of course, police are always the option, right? If there is an assault taking place or threats, if it gets into criminal action, the police should be notified. If it's a power of attorney for property that's being taken advantage of, certainly you want to talk to the bank, credit cards, any financial institutions. And then there are also some tribunals or courts that you can go to. So there's the Consent and Capacity Board, where you can challenge a finding of incapacity. And then you can also apply for guardianship at a court so that you can take over the role of caring for a person and making decisions on their behalf. And Shauna, do you have anything to add to that? I'm not sure if I missed anything.
I would just add that there are legal obligations for both in long-term care and retirement home residents. If we have a suspicion of abuse, it must be reported by law. So any regulated health professional who has a suspicion of abuse in those facilities must report it. Anybody who lives in their own home or out in the community, they would need to consent to a report to something like the investigations unit or the police or the bank. But there is a duty to report in long-term care and retirement homes.
So definitely that extra element of protection for people as they're getting to a more vulnerable state in their lives, ensuring that people are looking out for them. So picking your attorney, we got a lot of questions in this respect, so we're going to jump around a bit. But for those who joined me in January, you might recognize my little hierarchy or my little pyramid of decision making. So for the purpose of this pyramid, imagine yourself, you're always at the bottom. You are the first person who gets to make healthcare decisions on your behalf. It's only if you're found incapable of making a decision, and for that specific decision, there's then a hierarchy of people who can make decisions on your behalf. The first section is going to be anyone who essentially has a piece of paper. They've been appointed by a court, so they've got a court order, or they're your attorney, and so they have the physical power of attorney document to show to the doctors. If those do not exist, then we get into the zone of family. So the first people who can make decisions on your behalf is your spouse or your partner. And in the definition of spouse, that's going to include common law partners. So that's someone you've been in a conjugal relationship with and living with for 1 year. And your spouse isn't going to be someone who you are living separate and apart from because of a breakdown in the relationship or divorced. Next, you're going to have your children and your parents. So if you're in your 60s and you've got 2 parents and 3 kids, all 5 of them are on the same level of hierarchy to make decisions for you. You've got your siblings and then other relatives. So that's going to include anyone who's related to you by blood, marriage, so that could be a sister-in-law or a brother-in-law, adoption, and they haven't been divorced or separated from their spouse. So you get quite a wide range of people there. The Public Guardian and Trustees Office is your last resort. So if you don't have anybody who falls before them, they will be the last body to make decisions on your behalf.
Can I just jump in with one further definition? The legislation, the Substitute Decisions Act, also defines partner in the legislation, because this doesn't necessarily mean same-sex partner in a conjugal relationship. The definition includes any 2 individuals who live at the same address for at least a year, who are of primary importance in one another's lives. So that might be a mother and a daughter. That might be 2 sisters. That might be 2 friends. So a partner can also fall in under this spouse partner. And so where we sometimes see this used is that if there's a lot of children, if there's 6 kids, but mom lives with one of those kids and has for the past few years, that one child may actually qualify higher in the hierarchy as a partner. So just to be aware that there is some language around that in the legislation as well.
And I should note as well too, because common law partner is that 1 year only living together, being aware that they could actually then trump your children in decision making. So it's why it's always a good idea if you do want your children and you've got a relationship, you want to make a power of attorney document in that case, because your common law partner could essentially make decisions on your behalf, even though you've only lived with them for a year. So a lot of tricky definitions. So the responsibilities of the attorney. So there are actual responsibilities laid out in legislation for what your attorney should be doing. And they have a number of duties. So one is they've always got to encourage you to be part of the decision-making process. You don't want an attorney coming in and saying, I'm in charge now, you go sit over there, I'm going to make all the decisions. They should always be including you in that. They also have to act in accordance with your last known wishes or instructions. And I think we cover that in more detail a bit later. But Shauna, I see you might be jumping in.
No, that's fine. Generally, just saying that the attorney is responsible for looking at the quality of life and the benefits of the actions that are taken. And just noting the actions have to be in the best interest of the person who gave the power of attorney. So it's not the best interest of the child who is the attorney, it's the best interest of the parent who gave the attorney. And the beliefs. So I often look at it as you're stepping into the shoes of that person. So you don't make decisions the way you want to make decisions, you make decisions the way the person who granted it would make decisions.
Which is why it's always so important to make sure you're communicating and speaking to the person you've picked about what you would want done in certain situations, or what your views on medical procedures are, so that they know, okay, just because I believe one thing, say about vaccines, I know my parent believes something different and I need to follow what they want done. And then they also need to always be considering the quality of life of the grantor, and making sure that they're trying to improve that as they take over the role. Another big aspect is also keeping a record of all of the decisions that you have made on this person's behalf, because you might get a call from the hospital one day and you step in, you make 2 decisions for them, and then your parent's fine and you don't have to do the role ever again. Or you could end up acting as an attorney for 5-10 years. And so it's very important, grab a journal and just keep writing down, today I had to make a medical decision. Today I had to make a decision about Meals on Wheels, so that you've got a record of what's going on. This is very important on the property side too. But even if you're acting as the attorney for personal care, you want to make sure you've got some record of what you've been doing in that role. You also have a duty to consult with the relatives and friends of the grantor who have been supportive of them, because they might know what the last known wishes are, or they might have discussed with this person what they would want done. So it's important to be including other people in the process, even though the attorney has the last say on the decision making. Again, should be fostering the grantor's independence and making sure they're part of the decisions, and then making decisions that are the least restrictive. So you don't want to be making decisions that are going to trap a person in a room and make sure that they can't do anything. You want them to still be independent and ensure you're not closing the walls in on them. So the prior expressed wishes. As an attorney, you have a duty to follow whatever the last expressed wishes of the grantor were. These must be taken in context. So it's very difficult for someone to say clearly what's going to happen in every single medical situation that they could have come across in their future, right? So people generally say very general things, right? Going back to the example of vaccines, you might have a grantor who says, I don't want vaccines, make sure I don't get any if I'm in hospital. Yet when you see their medical records and you're acting for them, you see they've gotten a tetanus shot every 10 years their entire life, right? So that might change the context of, okay, I can authorize this kind of medical procedure, but maybe there's other ones they wouldn't want me to act on. So you always take it in the context of the new information you're receiving. Those prior expressed wishes can be expressed verbally or in writing. So if the person can't speak anymore, if they're still trying to communicate with you while they're capable and telling you what their wishes are on something, you can follow that. It also means you don't need them in writing, right? You don't need to have a signed document with a date and it's notarized to say, this is what I'm following. If your mother 2 days earlier, while capable, said, I never want to eat pudding ever again in my entire life, and the doctors are handing her pudding, well, you know what her last wishes were. I don't know how that context would change, but you can look at it.
So I'll just note there that there's also a limitation on prior expressed wishes, right? There comes a point in many people's lives that their wishes can no longer reasonably be honored. So my own mom has told me for years and years and years, she shall never live in a nursing home. Well, I will follow that expressed wish to the best of my ability, but if she requires 24/7 care and I can't give it to her, or she can't afford 24/7 care in her home, it might become necessary for me to make a decision in her best interest that may go against her best wishes or her expressed wishes. And that is the responsibility of the attorney, is to follow the wishes to the extent that's reasonable and possible. But if it's no longer possible, you have to work in their best interest.
And so when we're looking at then who can be your attorney, right? Who can you actually pick for this role? Really what it comes down to is you can't pick somebody who you are paying to provide services to you. So that includes healthcare, but also residential care, so your landlord, social, so your social workers, PSWs, anybody you're paying can't be your attorney unless they are your spouse, partner, or a relative. So the example I've provided here is that you could have a son who's paying rent to his mother. He lives in a unit of the house. They've got a close relationship. He wants her to be his attorney. So she is not barred from that role just because he is paying her some compensation. So this does ensure that you're not going to lose out on potential attorneys if you happen to be paying your family to provide services to you. So is the attorney ever compensated? And for those who joined me back in January, I did make an error on this part, so I'll correct it now. So yes, your attorney may be compensated. There are differences. So if it is an attorney for property, it is actually laid out in the legislation, the amount they can be compensated for the amount of money that goes into the account and money that goes out of the account. So whether or not you outline that in the power of attorney document, your attorney should be entitled to compensation unless you say they're not allowed to have it. For the power of attorney for personal care, the legislation doesn't lay out that the person's inherently entitled to compensation, but you can include it in the document. So you could say, for every month this person helps me, they'll be compensated a certain amount. Always be careful with that because it's such a wide range of things that this person could be making decisions for on your behalf. It's a lot harder to quantify. How do we decide what they should be paid for which services? But it is possible. So throwing that out there. Can an attorney for personal care or property resign? So yes, they can. They can resign before they even start the role. So the second you need a decision maker, they could just say, I'm not going to do it, usually with a piece of paper, right, that they've signed and dated and it's been witnessed saying, I do not want to fulfill this role. They can also resign after they've started working for you. So if they've been in the role, say, for a few years, they're tired, they want to pass it on to your substitute, again, a signed letter dated and witnessed. In that case, they need to ensure anybody that they have worked with, so say it's a doctor or your pharmacist, they need to receive notice that they've resigned so that they don't continue to call them, right? They don't continue to rely on that person. So if I don't have anyone I trust, can I appoint the public guardian and trustee's office as attorney for personal care? And the technical answer is yes. You can name the PGT if you receive their consent in writing in advance. I don't know what they look at for that, but I can tell you it is very, very, very rare. So do not bank that you're going to get to put the PGT down to make decisions for you. Again, I don't know what conditions they look at to even make that decision. If you're uncertain about the people that you're considering as your attorney, right, and you know it's going to be someone in the family is going to make decisions for you regardless, one thing to consider is having two people working together jointly, right? So you could have a check or a safety net where two people have to make decisions. They have to discuss with each other before making any decisions on your behalf. You also don't need to name someone who's a family member. So if your issue is I don't have anyone in my family who I trust, but I've got a close friend, you can name your friend. There's no limitation on that. So a triggering clause. So important to keep in mind that your power of attorney for personal care specifically is only effective when you're found incapable of making a decision. And it's not a global incapacity. So no one's going to come along and say, well, you couldn't decide about pudding, so you can't decide about everything. Each decision needs to be evaluated and put to you by the doctor or the dentist, whoever is offering you the service. And then the document is effective if they find you can't make that decision yourself. It is different for the power of attorney for property, and that's why we're including it. So you know that there's differences. Power of attorney for property could be effective the day you sign it. And then you can just leave it in your suitcase or under your bed and give it to your attorney when it's time for them to work for you. Or that document could be effective when you're found to be incapable, in which case you need to have something stating who's going to find you incapable, whether a doctor or the capacity assessment office. So here's a question we received. If I am alone, my adult children don't visit often, who is the proper person to ask about power of attorney for personal care and property? So simply put, there is no proper person, right? If you're looking at your friends and your family and you don't know if anyone's going to fit into that bar, it's usually safer not to sign the document and try to fit somebody into a role that you don't feel comfortable having in that role, especially when we're talking about money and finances, because it is such a powerful thing that you're giving a lot of authority to someone over your property. So if you do not have family, then in that case, it would be the PGT that steps in and makes decisions for you. And another question we received, so why would supportive, I think in this case, there was the PGT was acting and making decisions for an individual, despite the fact that there was some supportive family members around. So if you have made a power of attorney for personal care, going back to that little pyramid I had, that's going to trump the PGT in decision making. Even if you don't have the power of attorney for personal care, then it's going to be your family members and then the PGT. If the PGT is already acting in that role, that usually suggests that there was a capacity assessment done or that they've stepped in, and someone just might need to apply for guardianship from the PGT to take over.
I think I would also just like to clarify that I think that this question maybe bridged the gap between a power of attorney for personal care and a power of attorney for property, because it's quite possible for someone to have a guardian of their money at the public guardian and trustee, and their family members making health and personal care decisions for them. And that's kind of the norm if somebody is on public guardian. So just remember that capacity is specific for different types of decisions. So it is possible for people to have public guardian for money and family members for care.
And just a good reminder too, then, that you can have multiple people working, right? So you could have those different bodies doing different roles, or you could have a different person being your attorney for property than your attorney for personal care. So if an incapable adult does not have family or a trustee and needs support with making decisions around personal care, who makes those decisions? So again, going back to that pyramid, right, there is that hierarchy of people who can make decisions for incapable adults, starting with the paperwork, then your family, then the PGT. All right, signing and witnessing documents. So can I alter the power of attorney once it's been signed? it's usually best not to, right? And we would recommend to, doctors or healthcare providers to ensure that whatever document they're receiving doesn't have whiteout on it, doesn't have alterations. An alteration can be made if it's been witnessed and dated again, but it's at that point, it's better to just make a new document. It would be very suspicious to see, somebody's name's been crossed out last minute and another attorney's been put in, especially when you don't know if that person was capable or not when that alteration was made. Can a power of attorney be signed using audio-visual technology? So when COVID-19 came around, the government changed the legislation to actually allow witnessing of the document using audio-visual communication technology. So very similar to what we're doing today. You can see me, you can hear me. If I can see my client and hear my client, they can actually sign their document in front of me, in front of the camera, and I would sign the document on my side and then send them my copy. This only works if one of the witnesses is a lawyer. So you can't just have all your family members on Zoom accounts trying to sign documents. In that case, you want to be together. A grantor has to be 16 to make a power of attorney for personal care, but how old can the witnesses be? They have to be 18. So funny enough, your attorney for personal care could actually be 16 years old, but your witnesses still need to be 18. Your witnesses also cannot be your spouse or your partner. They can't be your attorney who you've picked, their spouse or partner, your child, or anyone under guardianship. So just be very careful if you're making one on your own that you're following those witnessing rules. You're not just getting your spouse to witness the document for you. Does a power of attorney need to be notarized? So no, under legislation, there's no requirement that this document be notarized. You can sign it at your kitchen table with your neighbors as your witnesses, and that would be valid. You don't need to take it in. However, there have been some institutions that will request to have the document notarized or to receive notarized copies of the document just to ensure the validity of it. So sometimes it's a good idea to get a notarized copy, but it is not actually required under the legislation. So if I go to a notary public, do they have to assess my capacity? Generally speaking, I would say the notary public's role is to attest to your signature. So they are saying, yes, you are the person who you say you are. I've identified you and you were sitting in front of me and you signed this document. So it adds validity to the document. They are not trained to do the legal capacity assessment for making a power of attorney. Obviously, if they're brought into a hospital and a person's unconscious in front of them, that person's not signing the document. So there is a little bit of give there where if the person just has no clue what's going on, they might refuse to witness the document. But again, they're not trained to actually assess your capacity in this respect. Are the witnesses to a power of attorney also verifying the person's capacity to sign? So same thing as the notary. Your two witnesses are not trained to know what the test is for capacity to sign the document. So they're just there to say, yes, we know you, you're John Smith, you signed this document and we witnessed it. Again, there's going to be a little bit of give if they're brought into a hospital and you're unconscious in a bed and someone's trying to force you your hand. I'm hoping your witnesses are going to say, well, we can't witness that, right? But they're not trained to assess capacity. Safe storage and sharing. So a good rule of thumb actually is if you have a power of attorney document, anytime you share it, just keep a piece of paper, write down the date you gave it to somebody and who you've given it to. This is in case you ever need to revoke the document, or if you sign a new power of attorney, you just want to make sure you're giving the new copy to all the same people who received the old copy, so they're not acting on something that's outdated. Always keep an original copy of the document yourself. I deal with a lot of cases where people are being abused by their attorney, right? Their sons or their daughters, their grandchildren. And over again, I hear, I don't have the power of attorney, right? They have the only copy of it. We can still revoke that, but it's always a good idea to keep one yourself for reference and to make sure that you can then share it with people as you want to. Every family is going to be different, but keep it in a safe but accessible place. So maybe on your fridge isn't the best bet, but keeping it with other medical documents or, bank statements, somewhere where someone knows how to access it if they really need it in an emergency, but someone's not just going to steal it from your house when they come and visit you. There is no power of attorney registry, so you can't file it with the court or anywhere specific, and everyone's going to say we have 1,000 power of attorney here, we can find them. Are digital copies valid? So for starters, you cannot sign electronically. You still have to sign physically in person, even though you could use, say, Zoom or another audiovisual technology to sign. You still can't, copy and paste it onto the document. You've got to print it off first. Most institutions are going to require a physical copy of the power of attorney. So be very careful about someone showing up, with a picture of the document on their phone saying you got to rely on this. It's best to have the original physical copy. Should I give the power of attorney to my attorneys? So again, I'm going to make that distinction between the power of attorney for personal care and the power of attorney for property. When we're talking just about the personal care side, that document's not effective unless you're found incapable of making a decision. So someone can't run around with it and make decisions on your behalf, willy-nilly. So it is generally a good idea to make sure that your attorney has a copy of the document so that if you're in an emergency or something suddenly happens, they're able to show up with the document and start acting right away. They don't need to go digging through your house or ask around who has the document. If you don't give them a copy, again, a good idea just to make sure they know where to find it. They're going to need the actual document if they're going to rely on it. If it's a power of attorney for property, it's going to depend on the effectiveness date. So if it's effective right away, you might not want to give that document to your attorneys right away. You might want to sit on that for a few years and decide when to give it to them. So different considerations for different documents. Should I give it to my children? That's, again, every family is different, right? If you're in a situation where your children are maybe not approving of you having a power of attorney or have been abusing you, you might not want to give a copy to them. If your children are your attorneys, probably a good idea they have it or they know where to assess it. So there's no rules saying you have to give it to certain people and you don't have to give it to other people. It's going to depend on your circumstances. What you want to ensure is that when something happens, because it really is an emergency document, when you're in an emergency, is someone going to be able to get the document and be able to rely on it? So here's a question we got. Sally asked me to be co-attorney with her executor. I signed a document but was not given a copy. It was given to the intended executor. When Sally went to hospital, I did not have a copy of the document and I was not able to make decisions for her. So there's a lot to unpack there. For starters, keep in mind, and maybe I'll let Shauna jump in on this one.
Yeah, so when I tried to unpack this one, I was very much aware of the way words get twisted around to have different meanings for different people. So I just want to clarify for people that an executor is something on a will. An executor is a person who administers a will after a person dies. So nobody who's living has an executor on a power of attorney. A power of attorney document has an attorney. And so there can be one attorney, two attorneys, there can be people working together, but an attorney can only work while a person's alive. An executor only works when somebody's deceased. So just the wording of the question caused me some pause right from the get-go. But from that point, and we've already talked about, if you don't have a copy of the document, you can't make decisions. You have to actually have the document physically in your possession and present it to people in order to be allowed to make decisions, even if you were. Also important to know that if you're agreeing to be someone's attorney, you really need to fully understand what it is you're being asked to do and what is expected of you. Because this is a job. This is not an honor. This is not something that people should enter into lightly. you need to, if you're going to agree to be an attorney for someone, you need to understand what exactly they're asking you to do. So I had a lot of concerns about this question, but at the end of the day, it was appropriate for the hospital not to allow this friend to make decisions because they didn't have the power of attorney document that said they were allowed to. And B, there's some questions about just what it was they signed in the first place.
And I think this goes back to when we're looking at that hierarchy again, it sounds like in this case, Sally is a friend of the grantor, right? So this person wouldn't have had natural authority to make decisions for the attorney without the document. So again, if you want your friends to be your attorney, you've got to make sure they've got that document or are able to access it. Should I give my power of attorney to my doctors? There's no golden rule. If you are receiving regular medical care, generally a good idea then give it to your family doctor, ensure they have it, but not everyone's going to need it, right? Your dentist probably doesn't need a copy of your power of attorney unless you're going in for a very extreme medical procedure, right? And your dentist says, we'd like to know who's going to make decisions for you if things go wrong. It's going to be a call each time, but you always get to decide who has a copy of this document and who doesn't. And does the long-term care home or retirement home require a copy of my power of attorney? So technically no, right? No one can require you to give a copy of this document or require you to make the document. That's very important as well. We hear that a lot of, they say I have to have it. You do not need to have this document. But if you are living in a long-term care home or retirement home and you've got this document, you may want to consider sharing it with them because if there is an emergency or something happens, they should know who needs to be called or who can make decisions on your behalf. So it comes down to your comfort level and your own emergency planning. How do I know the document is the latest signed document? So it's always the last signed power of attorney, which is the valid one. And here's the terrible answer is you don't. There's no registry. So you don't know if the document you have is the most recent. Check the date. But unless somebody comes up to you and says, wait a minute, that was signed in 1999, and I know she signed one again in 2010, well, where's the document, right? They need to actually provide it to you. You're going to rely on the last signed one that you receive, unless there's a revocation. If that's attached to the document, don't rely on that. And this is also why it's important to talk to your friends and family. So if you're going and making a new document, giving a copy to your attorneys lets them know, okay, the old one's gone, use the new one so that people are all on the same page. What if I cannot find the originals? So it's usually a best practice for anybody who's relying on this document to rely on the original copies. Like I said, you don't want to just get a picture on a cell phone and say, yep, fine, you can make all the decisions for this person. So rule of thumb, no document, no power of attorney, right? Someone doesn't get to show up at the hospital and say, I'm the attorney, you have to listen to me. They need to have that document in their hand. Keep the documents that you have in a safe and accessible place. A lot of time is spent with people running around, trying to find documents, talking to family members, someone showing up suddenly with a new copy. So communication is really key in this sense. If you've gone through a lawyer, maybe telling your family which lawyer you use to make the document, where it's hidden, right? So they can find it. So what is a direction to release power of attorney? Why won't the lawyer provide information about the conditions, about what the conditions are for release of power of attorney? So in this sense, I mean, anytime someone meets with a lawyer, there is actually client solicitor privilege. So they have to keep confidential any information that was shared with that client. Unless that client signs a direction for release saying, if somebody contacts you, you can give this document to someone else. So why it's usually best practice, if you are having specifically a power of attorney made with a lawyer, you should make sure you have a copy of that document before you leave. It's not the same as with wills. Another thing is there might be a condition to release the document. So if the document's not effective until you've been found incapable, the lawyer's instructions might be to hold on to the document until they've received a doctor's note or a capacity assessor's certificate saying you're not capable, or they might not be authorized to share the document with everybody. They might be told you can only share it with certain people if they contact you. So the lawyer is going to follow whatever's in their contract and whatever they were authorized to do. You're not going to be able to trick them into sharing it with you. And that concludes our first half. So I'm sure there will be lots of questions that have come up.
Thank you so much. There are quite a few questions that have come up. I'll go through the Q&A box with you if you don't mind. One, what about requiring that a caregiver be notified about outings as caregiver maintains the elder schedule of doctor's appointments, etc.? So I guess the question here is the POA being required to connect with the caregiver. Is that possible?
I'm not sure if I've completely understood that question. So is
Let
the
me
attorney...
read it again.
Yes, thank you.
What about requiring that caregiver be notified about outings as caregiver maintains elder schedule of doctor's appointments, etc., pays for care, which would not be necessary if there is an outing? So I guess the person is in a home.
Okay, so
maybe we'll leave that one because there are so many. If it's not clear, maybe the person who asked can
excuse me, just a note from the interpreting team. Sheila, your sound isn't very clear and it's a little hard to understand. I don't know if you can adjust your audio.
All right, you know what? It might be my internet. I am living in rural and I have a snowstorm. Mary, I might let you give it a try.
No worries. I know you may be having some trouble with the internet. So yeah, quite a few questions. I will try and pick up where Sheila had just left off. So many are coming through about, again, asking if, and again, just keeping this very general without speaking up too personal, if the senior has dementia and other family members are visiting and don't understand that journey the senior is on and are agitating them, does the POA have the right to tell the family not to visit anymore because they're causing distress to the senior?
So I'm going to jump in on that. I mean, we're considering the best interests of the client with dementia. So the power of attorney is going to have to weigh out what is the risk of cutting them off from loved ones compared to the risk of being agitated. Does the client enjoy the visits when they're there? Does the client enjoy having people come in the first place? Does the client ever express that they want to see that person? You can't just willy-nilly say, oh, this person agitates mom, I don't want them to come anymore. If mom actually enjoys visiting with them, then mom should be allowed to visit with them. And maybe the family who agitates them needs some education or some better communication with how to work with mom.
And to be clear too, agitation, very different than like an imminent risk to a person, right? It's not hitting that harm standard where this person's safety is at risk. And so your attorney really shouldn't even be preventing them from visiting at all, right? The person has a right to visitors, and the fact that they would be doing that without even consulting then with mom and saying, you've got visitors, like Shauna's right. Does mom like seeing the visitors? Well, if someone's considering cutting mom off, they should be talking to her and saying, do you want these visitors to see you?
Thank you. Well answered. Thank you. Another question, quite a few that have come together that people are asking, or what happens when the POAs don't agree on placement for long-term care? Does the PGT take over? Do we have to go to court? What happens?
So the hierarchy that has been put up a couple of times. So let's use the scenario that the children are all the equally ranked power of attorney. So you have 6 kids, try and get 6 kids to agree on something. So the legislation requires that the family, the equally ranked people need to reach an agreement, a consensus. If they can't reach a consensus, then the legal step is that the public guardian would make decisions in their place. So not with them, not communicating with the family and hearing all their sides. It means the public guardian talks to the doctor and makes the best decision they can based on the information the doctor gives them, which is this much. So it's really in your best interest and in the family's best interest to find an agreement, because otherwise some government person is going to make the decision in your place.
True. Excellent. Thank you. And can the attorney be someone who lives outside of Canada?
Yes, they can. So you can pick, again, as if you're not paying them to provide services to you, and they're not family, you can pick any attorney. So if they're living in Japan, they can be your attorney. The thing to keep in mind is, are they accessible? Right? Can we get hold of them? So if you're suddenly going to be taken to hospital, or you've got a lot of medical needs, your capacity could be at issue on and off, you want someone who's going to actually be reachable on the phone. There's so much technology nowadays that, again, they don't need to be in the room, but you got to reach them somehow and verify their identity.
And so the legislation requires an attorney to be available and accessible, and willing. So as long as they're available and accessible and willing, then they can be anywhere.
Excellent, thank you. And quite a few questions again, just trying to please, if you can tell us again, understanding when power of attorney for personal care becomes effective, when does power of attorney for property become effective? Do we both need to, does the patient need to be incapable for both? There's sort of, I think people are just trying to get a clearer understanding.
Let's defer that because we're going to talk more about capacity in the next half. So let's just leave that one for now.
Excellent, thank you, Shauna. And just before we go, quite a few more questions here. So looking at, again, and a lot of these are when about deeming people incapable. So I know we're going to get to a lot of this in the second half of our Q&A. So no worries there. We will get to all those questions that everybody's asking about capacity and assessment, whom can deem assessment, how that is done. A lot of questions about cost are coming up there. And if another question here, a client came through, I went to see a lawyer and did not get the POA for finances. I was advised that she did not know enough about us as a family, how to do this. The lawyer was very impatient and frustrated at the time of the meeting. Am I able to report this if this happens?
So the first step is if the lawyers don't have to provide a service if they don't feel competent to provide it, right? So if it is an issue of going into a lawyer and they're saying, this isn't a service I can provide, or I can't get enough information for it, the lawyer isn't obligated to provide that service. If it's a deeper issue, I mean, issues with lawyers can be reported to the Law Society of Ontario, and then they will choose whether to investigate it or not. If it's, I'm trying to understand the different elements of the question. If it's the lawyer has made the power of attorney, but not provided it, actually, I'm not even sure how to answer that. They should provide you a copy if you ask for it. Shauna, do you have any thoughts?
No, I think,
okay.
Yeah, I think it's being unhappy that the lawyer would not make a power of attorney. And there's lots of good reasons why a lawyer might not make a power of attorney. So I think that's way too broad for us to answer in this context.
Thank you so much.
I'll add in quickly too. So my role as a lawyer is to assess your capacity to sign the document, right? And the standard for power of attorney for property, it's 7-part test. So if I have a client who can't give me that information, then I'm not going to make that document, right? I can't forge a document on their behalf if they're not meeting the standards. So that could be an issue as well.
And then a few other questions did come up rising again about that the most current power of attorney, of course, is the one that's got the most up-to-date date. And a few people had said, well, what if family just continues to change those POAs and keep, you know, changing the date so it goes back and forth between siblings?
My question would then be, is that client capable of signing documents? Like, in theory, you could sign a new power of attorney document every week.
Yeah.
In reality, no capable person's going to do that. So we would be looking at capacity pretty quickly then.
Excellent. Thank you so much. Okay. And so that sort of hopefully answered quite a few of the questions. We tried to group as many as we could together to get them all answered. The chat box is also lighting up with just saying, thanks for all the great information, so much high level oversight. So a lot of great compliments are already coming through as we will continue on. So thank you so much.
All right. So I'm going to talk to you about capacity assessments. And I don't think I have control of the slide deck at this point. So I don't know who's controlling that.
I'm going to make sure you have control, Shauna. Just give me one quick second.
Sure. Problem.
There we go. Should be good to go.
Okay, so I'm not seeing your screen shared. Do you want me to share it from my screen? Is that what?
If you'd like to share from your screen, so you can move the deck.
Shauna,
Okay.
do you want me just to put it up and then you just yell at me?
Yeah, I don't have.
Okay.
I don't have the deck open.
Great. Thank you, Megan.
Thank you.
Are you able to see that?
Perfect. Excellent. Okay, capacity and capacity assessments. So just so you know who I am, so I am an occupational therapist by background, and I'm a designated capacity assessor. So I'm one of a small group of designated capacity assessors in Ontario. We as a group are only in Ontario, and our role is to assess in the legal context whether someone has the ability to make decisions. And so capacity is one of those words that gets thrown around a lot to mean different things. In this context, capacity means the legal ability to make decisions about issues that affect you. So this is not physical capacity. This isn't does somebody have the physical ability to walk down the street. It's not functional capacity. Do they have the ability to live alone? It's mental capacity, cognitive capacity. Do they have the ability to make decisions about the issues that affect them? Okay, go ahead. So first question is, do I have to prove that I'm capable? So no, in Ontario, we are all presumed to be capable. When we turned 18 for money and even younger for personal care, we are presumed to be capable of making decisions that an adult would typically need to make. So it's not necessary to prove you're capable. It's necessary for someone to prove you're not. Okay, go ahead. So I guess there was some confusion previously about the age for presumption of capacity for personal care. Now, the interesting thing about capacity is there's no upper limit at all, ever. So you can be 125, it doesn't matter. There is no upper limit in age to capacity. The lower limit for money is 18. The lower limit for personal care, though, is dependent on whether that child at that point has the ability to understand and appreciate. So there are some 12-year-olds who are highly emotionally intelligent and are able to have a reasoned conversation with their health providers to decide whether they want a treatment or they don't. So you don't have to be 16, you don't have to be 18. You just have to understand and appreciate the decision that is being proposed to you. Okay, so that's a big difference between the personal care and the property legislation. Okay, you do still have to be 16 to sign the power of attorney document, because that's deciding who would make that decision in your place is a little bit more of a complicated decision than actually having the doctor as a gatekeeper. All right, go ahead.
And I'll just step in quickly there and apologize. I was the one who was presenting back in January. So anyone who was part of that, when I did say that you had to be 16, that is incorrect. So just be aware that if you rewatch it, you know, for fun before bed, don't follow that.
All right. So what does capacity mean? So I already touched on this. So capacity in this context means the ability to make decisions. So it's a cognitive, it's a mental test. So a person could be completely paralyzed and still be completely legally capable of making decisions. As long as they can say what they want someone else to do for them, they can be capable. Okay, go ahead. So there's two pieces of legislation that govern capacity in Ontario. So the one that does the legal side of things is the Substitute Decisions Act, so the SDA. And so it outlines sort of the test for decision making, the test for capacity. The other one that I will talk about is the Healthcare Consent Act. Now, the Healthcare Consent Act is where the little hierarchy that Megan had with her pyramid of who makes decisions. So it's actually the Healthcare Consent Act that outlines those rules about who makes decisions when about treatment and about long-term care. Okay, go ahead. I think that's a duplicate. We'll go ahead again. So very important to know that there are different types of capacity. There are different types of medical and legal capacity, and they're all separate and distinct. So I can't tell you the number of times I've had someone present to me to say, this person's incapable, I will make the decisions. So my response as a healthcare provider is incapable of what? Because they're all different. So people can be capable or incapable of money. They can be capable of or incapable of health, safety, shelter, nutrition, hygiene, clothing. Just because you're incapable in one area does not mean you are or you aren't in another area. So granting a power of attorney, executing a will, consenting to medical treatment, those are all separate and distinct tests. So there is no, in Ontario, there is no overarching finding that someone is incapable of doing everything from now on. Okay, so be very careful about that, that if you say someone's incapable, they are not incapable in a global sense. They are incapable of that thing that somebody assessed them to be incapable of. Okay, go ahead. So we've got lots of different types of capacity assessments. So Substitute Decisions Act outlines that designated capacity assessors, such as myself, we have roles to do assessments that have the potential to remove someone's rights. So their legal rights to autonomy, their legal rights to make their own decisions. So a designated capacity assessor has to do an assessment where we're looking at a guardianship application going to a court, where we're looking at the office of the public guardian and trustee becoming a guardian of the money. Designated capacity assessors, we're medical professionals, but we've all been specifically trained through the Ministry of the Attorney General and through the office of the public guardian and trustee. So not all doctors, not all occupational therapists, not all social workers are designated capacity assessors, but all designated capacity assessors are either a doctor or a medical nurse or a social worker. Okay, go ahead. So medical capacity assessments, on the other hand, can be done by all the regulated health professionals. So doctors, nurses, therapists, social workers. The Healthcare Consent Act says that before any health provider can do treatment or who can admission to long-term care or support services, they must evaluate capacity to see if this person understands what is being proposed. It's called informed consent. And you can only get informed consent from someone if they understand and appreciate what it is you're asking them to do. So in this case, medical capacity is decided on doctors and nurses in hospitals and in doctors' offices every day with every interaction with their clients. They would only call in a designated capacity assessor if it's a particularly complicated or difficult or contentious situation. somewhere where there are differing opinions about whether someone does or does not understand and appreciate. So typically, medical capacity about treatment and about long-term care placement, that's typically done by the doctors, the nurses, and the social workers and the therapists. Okay, go ahead. And then the last one is the more of the specific legal document. So the power of attorney documents or the will documents, this is the lawyers are the gatekeepers here. So again, you don't need a designated capacity assessor to do these legal documents. The lawyers are primarily responsible to determine if someone meets the test, and Megan went through the tests for you, but the lawyers are primarily responsible to determine if the client understands what these legal documents are and if they can appreciate the risks and the benefits posed by signing those documents. And so this is where it's important. We talked a little bit about the notary and about the different people. This is where the lawyers are that gatekeeper to know the assessment. They might call in the capacity assessor again in a particularly contentious situation, maybe as due diligence, just to say, we want a secondary or an informal or a third party assessment of their capacity. Okay, so go ahead. So I already said this once, I can't say this part enough. If you're incapable in one area, does it mean you're incapable in all areas? Absolutely not. Capacity is time and situation specific. It must be assessed in relation to the decision that's at hand right now. So just because someone can or cannot make decisions in one area, that doesn't translate to the other areas. Okay, and if you think about this in the most broad terms, power of a capacity to make decisions about nutrition might mean, can this person decide whether they will or they won't eat Brussels sprouts? Take that to the other end of the spectrum. Can this person decide whether they will or they won't have chemotherapy to treat their lung cancer? Okay, takes a whole lot more information gathering and consideration to make those decisions. The risk is much higher at one end of the spectrum than the other. Okay, so we can't say that someone is incapable of making everything, all decisions. Okay, go ahead. Can capacity assessments be done virtually? So by Zoom or by Teams or something? And yes, they can. That was new since COVID, that if a person has access to technology, if either they can themselves set it up or they have support that can set it up, they have to be able to communicate over the computer effectively. They have to be able to carry on a conversation with good hearing and vision. But as long as they would not be disadvantaged in any way by doing it over computer, there are some advantages. One particular advantage is we don't have to wear masks when we're on the computer. And so if someone has hearing issues and I'm wearing a mask, it might be much harder to communicate in face-to-face than it might be over the computer. So every situation has to be weighed based on its own particular issues, but it is possible to do it. And there are a lot of circumstances where it makes really good sense to do capacity assessments over video conferencing. Go ahead. So very common question and misconception that there's specific tests or specific documents that a doctor or a service provider uses to determine capacity. So the common ones are the mini mental status exam and the MOCA. MOCA and mini mental status exams are screening tools. They are screening tools for memory impairment, for cognitive impairment. They're not diagnostic and they are not indicators of capacity. So somebody can have a very poor score on a mini mental or a MOCA, and they might still be able to understand the situation that you are talking to them about. So there's no standardized tests for determining capacity. There's also no standardized diagnosis for capacity, right? Just because someone has dementia or has autism or has schizophrenia, that doesn't tell us whether they are or they aren't capable. Okay, we might use medical records to support as part of a piece of a puzzle, but it's not the test. The test is, does the person have the ability to understand? The test is, do they have the ability to appreciate the decision they face in the moment? So a capacity assessment is very individualized. It's very specific to that person and the things that they are facing in that moment in time. Okay, go ahead. So how are capacity assessments paid for? So again, just being careful that we know there are the three kind of major types of capacity assessments. So your medical assessment to consent for treatment, long-term care, support services, that's covered under OHIP. That's done by your doctors, your nurses, your therapists. Legal capacity to make property, personal care, power of attorney, or will decisions by a designated capacity assessor, those are usually out of pocket. So I, as a designated capacity assessor, am not covered by OHIP. So I am funded very much like the lawyers are, right? You pay for services that are rendered. There are some potentials for some funding from different places like nursing homes or hospitals, depending on where they are. But at the end of the day, I'm in private practice and I'm not covered by OHIP. So go ahead. So how much do these capacity assessments cost? So designated capacity assessment usually is in the area of $800 to $1,200. Now this varies a lot. It varies a lot by the expertise and the experience of the capacity assessor. Some capacity assessors are social workers and OTs, others are psychiatrists and psychologists. So you can imagine that there may be some with much higher levels of billing rates and much higher skill levels. Those that are being expert witnesses in court cases, their rates are going to be substantially higher. The price will also vary based on what exactly needs to be assessed. So if we're only assessing one area, if we're only assessing treatment, if we're only assessing personal care, or we're only assessing property, then it's probably $800 to $1,200. If we're assessing property, personal care, power of attorney, and will, well, now we're kind of doubling and tripling the work, right? Because they are separate reports. They're separate. The assessment itself might be part of the same, but there are separate reports and separate criteria that need to be documented. So it will go up. And travel is billed on top in most cases. So depending where you are in the province, that goes. Go ahead. How long does it take? So most capacity assessments by a designated capacity assessor take between 1 and 2 hours. Depends on how chatty someone is. If they are non-responsive or if they really don't talk very much, it might take 15 minutes. If they are a little more tricky and they're a little more elaborate with the things that they have to say, it might take 2 hours. So it really can vary. There is also gathering of collateral documents, medical information, interviews with other family members that could take another couple of hours. And then the report writing usually takes between 4 and 6 hours. So this is not your standard medical doctor's capacity assessment who writes 2 sentences on a script pad. Okay, this is going to generate a report that's multiple pages long that outlines how it is that we felt they met or didn't meet the test for capacity. Okay, go ahead. So very often we get people who call to say, you know what, mom or dad just won't agree to this. They won't cooperate. They won't participate. And so my recommendation to people is always that less is more. People tend to cooperate much more with strangers than they do with family members. And there's lots of reasons for that we won't get into. But if you're stressed about it and if you're worried about it, they're probably going to be too. And so my recommendation for people generally is to get the capacity assessor in the door. A nice lady is going to come and have tea with you. My job as a designated capacity assessor is to give them their rights advice. So I, by law, have to explain to them exactly what the purpose of the assessment is, what the potential outcomes are, and that they have the right to refuse. The tricky thing about working with people with dementias and cognitive impairments is if they don't think they're incapable, if they really believe they're capable, most of them are quite happy to show me. They're quite happy to prove it, right? And so I have to tell them what may happen if they are or they aren't capable. but oftentimes they're quite happy to participate because they're going to try to prove me wrong. And so it's all in the presentation. So my recommendation to people is just be calm and relaxed about it, and put it onto the capacity assessor to charm or schmooze with your loved one to get you in the door. Go ahead. How do I locate a designated capacity assessor? So there is a web page. You go onto the web page. It has the list of all the assessors in the province. You can sort it in different ways. It shows where they each live and what languages they speak, and whether they are occupational therapists, social workers, doctors. They're different things. Know that their availability and their experience and their costs will all vary. So you may need to try and reach a few of them in order to find somebody who's available, and the costs will certainly vary. So you want to do a little bit of legwork and a little bit of research before you settle on one. Okay, go ahead. So this is a common thing. How do we navigate if there's a fluctuation in capacity for personal care? So for instance, assessment and doctor's appointments. So in the dementia world, it's very common for people to have what we call sundowning. So they might be perfectly lucid and having a wonderful conversation at 9 in the morning, and they might be very, very confused and not able to carry on a conversation at 4 o'clock in the afternoon. So again, we come back to capacity is time and situation specific. So we can't deem someone incapable at 9 in the morning and say forevermore they are incapable. Every time we see them, a healthcare provider has to decide in that moment. Now, here I'm talking about treatment decisions. So I'm talking about going to the doctors. I'm talking about going for an X-ray. I'm talking about medical treatment decisions. That nurse or that doctor needs to decide in that moment whether this client is able to consent to that treatment. Do they understand what is being asked of them? Do they understand the risks and the benefits? Do they appreciate what it means to have or not have it? If they don't, then the doctor or the nurse will move to the substitute, move to the highest ranked decision maker, whether that's the power of attorney or the family member, depending on that hierarchy. Okay, go ahead. So scenario, I have a client whose power of attorney found a doctor to deem him incapable, but his other family members are saying that that is incorrect, and they have proof that the current power of attorney is grossly misusing funds. How may he move forward with appointing someone else? Okay, so there's a lot of stuff to unpack in this question. First thing is, I have a client whose power of attorney found a doctor to deem him incapable. Okay, that sentence is not actually correct, because a doctor cannot deem someone incapable for everything. We don't know what the doctor felt he was incapable of. The doctor probably felt that he was incapable of making treatment decisions, because that's the scope that doctors are working within. So the doctor really doesn't have much say about whether the client can manage the money, typically, but I mean, they could. The family members are saying that's incorrect, and the power of attorney is grossly misusing funds. Okay, so whether the client is capable or incapable really doesn't have any bearing on what the attorney is doing in misusing funds. So we need to be careful that those are actually two distinct issues. And how can the client move forward with appointing someone else? Okay, we'll go on to the next slide. So the test Megan already went through with you. So the test for capacity to make money decisions is not the same test that's used for granting or revoking power of attorney. The doctor's job is to apply the legal test for capacity to grant, or it's not the doctor's job to see if the client can grant or revoke the power of attorney. That's the lawyer's job. So a person may not be able to make decisions about their income or their expenses or their assets, but they might be able to make decisions about who they trust to do that for them. Okay, so here we're looking at those levels. We're looking at the test for power of attorney kind of requires this much. The test to actually manage their money requires this much more. So they're not the same test. So my recommendation in a case like this is, if the client themselves is seems to be capable of granting a power of attorney. If they understand what's going on, they are saying, hey, I don't like the way Joe is managing my stuff, I want to pick someone else, then maybe they need to go to a lawyer and talk to the lawyer about firing Joe and getting someone new. The lawyer is then the gatekeeper. The lawyer will decide, does that person understand and appreciate what they're asking for? They might ask for an assessment by a capacity assessor. They might not. It really depends on what the lawyer sees in that point, in that place. If they get to the lawyer and the lawyer says, no, sorry, this man really can't do a power of attorney, then the rest of the family could apply to court for guardianship. It's a very long process, a very expensive process, but it's a possibility. Okay. I'll go ahead.
And I'll just add very briefly there too, just because someone is authorized to be attorney for property, if they are misusing funds or stealing funds, using it for improper purpose, that is an offense, right? So it isn't, you're not just stuck with that person if they're actually stealing money. It can be reported to the police.
And that goes back up to what we talked about earlier with those, what recourse do I have? So there was that reporting to the police, reporting to the retirement home, reporting to the consent and capacity. There's different things. Okay, another scenario. So I recently spoke with mother's family physician to inquire about getting her powers of attorney updated and her will. The doctor did not agree that she was competent to make decisions about these documents. My mother does have dementia, but she's not incapacitated. The doctor had no advice or knowledge of where we could go to learn more. Okay. So next page. So my first question is a little bit facetious, but really, would you ask a plumber why your car doesn't run? So you're asking a doctor for legal advice. Okay, lawyers talk to you about power of attorneys and lawyers talk to you about wills. Doctors talk to you about medicine and about medical. So although mental status may become part of it, the doctor's not generally trained in the test for writing a will or writing a power of attorney. So I think if you want to write a power of attorney or change your will, you probably should be talking to a lawyer more so. And then again, remembering that capacity is domain specific. So unless the doctor asked her specific questions about her will or her power of attorney or her money, he probably didn't even come close to assessing capacity to grant or revoke legal documents. He may well have formed an opinion about capacity to make medical decisions or maybe to make money management decisions, but I doubt very much the doctor ever asked a client about whether she wanted to change her power of attorney and who her options were and what it was that needed to be managed. Okay. Other. So can I do an advance directive without having an attorney for personal care? So yes, an advance directive is a separate piece of paper. And as we talked about earlier, you can write your wishes on anything. You can just verbalize your wishes. So you don't have to have a power of attorney document in order to have an advance directive. The thing about it is that in Ontario, only people can provide direction to medical professionals. So a piece of paper cannot be handed to a doctor to say, this is what mom wants. There actually has to be a person who says, this is what mom said she wanted. Also knowing that even if you don't have any family, if you don't have anybody who fits in that middle section of the hierarchy, everybody in Ontario still has a substitute decision maker because the public guardian is the decision maker of last resort for treatment and medical decisions. So it's not ideal, but if you know you don't have any family and you still want to have an advance directive, in theory, you could draft that and provide it to your doctor or provide it to people that work in your care. They might look at it and consider it down the road. I don't think that's necessarily a great option, but I mean, there's nothing to stop you from doing an advance directive and hope that people actually read it and go on when you don't have a personal care attorney to actually act on your behalf.
It seems like a way to essentially put your wishes down in writing so somebody can use that in context going forward.
Mhm. Yeah, the tricky part is that you can't, so for instance, I can't write on a piece of paper, if I am in a coma, let me go. And then just expect the doctor to follow that. The doctor cannot follow that. The doctor can only follow that if my power of attorney or my immediate family, whoever's highest, says Shauna does not want to be resuscitated if she's in a coma, right? So there has to be a person. Can I rely on a power of attorney made outside of Ontario? Can I use my Ontario POA outside the province? So again, this will vary a little bit. In general terms, if your POA meets the requirements of where you've either come from or where you're going. Yes, okay, so I just wanted to double check. So both directions, as long as it meets the requirements of the new place. So put this in easier terms. If you live in Ontario, have a power of attorney, you go to Quebec. If Quebec recognizes Ontario's rules, Quebec may allow you to use that power of attorney and vice versa. But it depends on where you're going. So it's not universal. It's something you definitely would need to check. Snowbirds going to Florida. I know of many cases where people actually have two sets of documents. They have an Ontario set of documents and they have a Florida set of documents in order to deal with whatever place they are living in that time. So be careful of it, but it is in theory possible. Go ahead. Questions?
Wonderful. Thank you so much, Shauna. And again, Megan, a lot of the questions in the Q&A box were already answered in the second half. So thank you so much. But just a quick one that came up. A few people said, so is it possible to have a capacity assessor assess one's capacity to grant a POA?
Yes, it's possible. It's not necessary. Okay, so just distinguishing. So my recommendation is always to people, go to your lawyer first. If your lawyer doesn't feel comfortable, your lawyer wants additional information, they might recommend a capacity assessment by an assessor, but it is not a requirement. It is not a necessity. So go to the lawyer first.
Perfect. Thank you. And again, just one more, a few questions again said, so again, just to ask, who can deem a person incapable other than the consent and capacity board assessor?
Okay, so I'm not a consent and capacity board assessor. I'm a designated capacity assessor through the public guardian and trustee. So just be careful, because consent and capacity board is a tribunal, is like a court. So the only people who can do capacity assessments to remove someone's rights to make their own decisions, the only ones who can do that for property matters and in a legal sense for guardianship are designated capacity assessors. Doctors can deem someone incapable of making medical decisions or of treatment or of long-term care decisions. Lawyers can decide if someone's capable of doing a will or a power of attorney. So it depends very specifically on what type of capacity you're looking at. So there are some roles that only designated capacity assessors can do, but there are a lot of roles where we might be called upon to provide our opinion and to consult on a difficult case.
Excellent. Thank you. And final question, just before we wrap up, is there any financial help for those who cannot afford to have a capacity assessment paid for on their own?
Yes. So the Capacity Assessment Office is a branch of the Public Guardian and Trustee, and they do have, for people who are low income, fixed income. So if they're on ODSP, if they're on old age security and GIS, the person who's requesting the assessment, the person asking for the assessment, can apply for funding to have a capacity assessment done for property issues only. They will not fund personal care. They will not fund power of attorney assessments or will assessments. They will strictly do, they need a substitute? Do they need a guardian to manage their money? And if they do need a guardian to manage their money because they're at risk and they don't have the funds to do that, then the Capacity Assessment Office has some funds available to do that. that is really the only sort of specific capacity assessment funding that's available. There are other places where people can get quite creative with asking for funding, but that's the only one that's designated specifically.
Perfect. Thank you so much. And again, on behalf of the entire staff and team at Elder Abuse Prevention Ontario, we want to thank Megan and Shauna for such a wonderful oversight, high level today on the follow-up questions that came from everybody. And I can probably guarantee you there will be another session needed, as we've had so many great comments, questions, and feedback from our participants today. So I've just put up their information here if you'd like to reach out to Megan or to Shauna directly. And again, all this will be made available through our website at elderabuspreventionontario.com early next week for you to access the recording. And there is Shauna's information one more time where you can reach out to her directly as a designated capacity assessor. And some resources for you to access through CLEO's website, where the CLEO Steps to Justice website will give you downloadable, all great free information on powers of attorney for property, for personal care, and for wills. Also looking at CLEO's guided pathway tools, which are also available in French. And these tools will help you in looking at how to make a power of attorney and how to make a simple will. So these are just some of the resources available for community legal clinics. You can find your local clinic by reaching out through the 1-800 number, and the Advocacy Center North for Elders and Senior, which provides services for seniors and elders in Northern Ontario. And for low-income seniors in Ontario, you can reach out to the Advocacy Center for the Elderly, as well as the Disability Law Center. So again, all these resources are also available through Elder Abuse Prevention Ontario, and also by calling 211 Ontario. They can help you with resources and community legal clinics. And some more provincial resources we've been talking about today, especially the Office of the Public Guardian and Trustee, and you can reach them by phone or through their website at the Attorney General's Office, Government of Canada, on.ca. Please note, we also have the Ontario Senior Safety Line, which is a 24-hour-a-day line available for support, information, and referrals. 24 hours a day, 7 days a week. All calls are free and anonymous. And please feel free to visit our website at elderabusepreventionontario.ca. That's www.eapon.ca, where we have an abundance of resources and tools and tip sheets available for you to come and view, and also available for download as well. We hope everyone can join us again for our second conference of 2023. It will be held on March 22nd. So my goodness, just around the corner as time is flying by. Registration is available through our website right now. This is a free conference. Once again, will be available virtually. So you can register through the link that we've got here, or feel free to come on to our website and join us for the 22nd of March. We will have a detailed list of speakers and the program available for you shortly. Our next webinar next week, we hope you can join us, as it's tax time once again. So the Ontario's new personal tax credits. We will be speaking with Jeremy from the Ministry of Finance. That is available free of charge once again for February the 27th from 1 to 2 p.m. And as well on Tuesday, March the 7th, working with our colleagues and friends, over at Theater. We will be hosting a webinar on Nishu, Nico Nikoi, Wrinkles, which will be a listening and learning and preventing elder abuse webinar with the group through Theater. So a very important webinar working with our friends through Theater. Hope you can join us there March the 7th. Again, thank you. My name is Mary, and my information, as well as my colleague Sheila, is available through our website. We hope that you take a few minutes to complete our survey. A link will be sent to all our participants at the end of the webinar. Your opinions and your feedback are very important to us. So I want to thank everyone for their time on this lovely Friday afternoon. Again, Megan and Shauna, a million thank you for the high-level information, insightful information that you brought to our participants today. The comments flooded in with huge amounts of thank you for clarity, for bringing this information that is so important right now as we navigate through POAs for personal care and for property. So thank you again.
Thank you.
Have a good afternoon, everybody, and a great weekend ahead. Thank you.